Well, hi there, Australian Veteran News viewers, and today we are going to be speaking with Craig McConaghy. Craig is a former Australian Defence Force lawyer. He's about 35 years of experience with the ADF as a lawyer. He's also a barrister in Queensland and Victoria, and he's been involved extensively in the areas of criminal justice, and particularly in the Defence Force in relation to war crimes, when he's served in places like Rwanda, Solomon Islands and the Middle East, and he's got an enormous amount of experience that he's going to share some of that with us today. So Craig, welcome, and perhaps we could start out if you could give us a little bit of an overview of your experience, and perhaps talk a little bit about maybe starting out with some of your experience, in particular maybe that experience in Rwanda.
Sure, thanks Mark. I was in Rwanda twice, initially as a peacekeeper with the second contingent of OSMID in 1995, and then returned in 1996 in a civilian capacity as a team leader with the Office of the Prosecutor of the International Criminal Tribunal for Rwanda. As you have indicated in your introduction, I have predominantly practiced as a criminal barrister, and that plus my military background was advantageous to the War Crimes Tribunal at the time. So as an Army legal officer on deployment, I was there to support OSMID, the headquarters, the commanding officer, with the usual range of matters that a legal officer deals with, disciplinary as well as administrative law, but also operations law. And this was pretty much at an early stage of Australia's involvement in international peacekeeping missions. There was, of course, Cambodia that preceded it. Also, there was the assistance provided to Somalia, but Rwanda came along in 1994, and we had the two missions to Rwanda in 94-95. So in addition to supporting our headquarters, I was the only legal officer for UNAMIR, and there were about 10,000 troops in UNAMIR, United Nations troops. So I was also supporting the headquarters, and principally was used to investigate and report upon issues arising, complaints, serious complaints, breaches, etc. One of those being the Kabeho massacre.
Okay, Craig. So can you tell us a little bit more about some of the detailed experiences that you had during that time? I mean, obviously you were providing legal advice, but what sort of things did you get involved in, say, particularly that the massacre you just mentioned then?
Okay, I had provided some legal advice in relation to the operation which had been conducted to move internally displaced persons, so refugees for want of a better word, from the camps back to their home communes. It was called Op Retour. The difficulty that I identified with that particular operation was that it was well known that when the IDPs returned to their home communes, they were often subjected to violence leading up to and including death. And with the United Nations mission being charged to protect the civilian population, that caused a certain problem, and Op Retour was put on hold for a period of time. It was then re-established, and I was sent down to Kabeho about a week before the massacre to report on essentially the gearing up of the second phase of Op Retour. And as most people are aware, that ultimately led to an incursion of the camp by the Rwandan Patriotic Army, who had other plans, and the massacre ensued.
So it was a pretty hairy time over there, wasn't it?
It was challenging, very challenging for all concerned. There was a lot of issues and a lot of.
So as a legal officer, what were some of the difficulties you have in trying to establish the basis for any kind of prosecutions, or even potentially working on the defence side of the proceedings?
Well, one of the problems was one of the initial problems was there was still a working court system to a degree. And I, obviously with the direction by my superiors, worked with the Kigali Central Prosecutor. The idea being that there were an enormous number of people who were being held in Rwandan prisons. I just can't quite remember the number now. I think the Rwandan prison system was designed to hold about 6,500 prisoners. And by the time we started providing support to the judicial officers, there are upwards of around about 35 to 40,000 people being held in these prisons, and it got worse. What was the fundamental problem was that those who had been alleged to have been involved in the genocide, and genocide is, they came to the prison without any records at all. And they were just simply dumped in these prisons. And the judicial system was overwhelmed. So the first step was to provide an identification process for these prisoners, and that's the support that we gave. So we essentially established a prisoner identification system, which was then spread out across the country to all of the prisons, and then following their identification and what charges had been laid and where the witnesses were, then the process of the civil prosecutions could commence.
Now, Rwanda, and I guess more contemporary operations, and even going back into World War II, we've had some articles that we've promoted on even historical perspective from Breaker Morant and his co-accused. There's a sort of there's a lot of difference in the circumstances in which we're talking about war crimes, aren't there? So I think it might be useful for people to understand what exactly is a war crime, what makes something a war crime, and where is the jurisdiction lie in terms of either prosecuting or defending a war crime as opposed to a civil crime.
Well, a war crime essentially is a breach of international humanitarian law. And international humanitarian law is what's referred to as the lex specialis, in other words, the law that will apply in an armed conflict, whether it's an international armed conflict or a non-international armed conflict. In the Rwandan situation, there were in fact two situations happening at pretty much the same time. There was the genocide, which was an attempt by certain Hutu ministers and powerful men and women, I might add, within Rwanda to destroy the much smaller Tutsi population. And so that was a civilian led and directed attack, widespread systematic elimination, genocide, as well as other types of international crimes. In addition to that, there was the civil war that was occurring between the Rwandan Patriotic Army and the Rwandan army of the Rwandan government. And there were breaches that occurred in that environment as well. So Rwanda had across the board breaches, whether it was of the law of war or fundamental human rights abuses, which ultimately rolled up into what became the statute of the International Criminal Tribunal for Rwanda, so genocide, crimes against humanity, and war crimes.
And is every nation in the world answerable to these sorts of charges?
Basically, yes. Since the ad hoc tribunals had been established, that's the one in Rwanda and the one for the former Yugoslavia, the International Criminal Court has been established. Australia and I don't now know how many, but well over 150 countries ratified that particular statute, with some notable exceptions, which includes the United States, amongst others. But fundamentally, there are two aspects to this. There is the customary international law, which applies regardless of the Rome Statute, the International Criminal Court statute, and then there is the specific statutory provisions within the Rome Statute. which I might add have been incorporated into our Commonwealth Criminal Code. So all of those offence provisions in the Rome Statute are part of the domestic criminal law of Australia.
Mm. Okay, now we bring it back to Australia. I mean, we know, and I don't want to speak about it in any sort of detail, but there are allegations at the moment of potential war crimes against Australian soldiers, particularly in the Afghanistan conflict. And I think one of the things that I'm personally quite interested in is to understand, what are, from your experience, what are some of the issues of relating to command responsibility and supervision involved in pursuing or indeed prosecuting war crimes?
Well, indeed, Mark, there is a provision within the Commonwealth Criminal Code that deals expressly with command responsibility. And without going into detail, essentially, commanders as well as superiors have a responsibility to provide the necessary leadership in time of armed conflict. And if they don't, if either they acquiesce to what is occurring or turn a blind eye to it, they themselves could be prosecuted for the crimes committed by the men and women under their command.
And is there anything that sort of reaches back into? I mean, obviously that's people on the ground. Does anything reach back to, the politicians who sent them, and the sort of the bigger circumstances surrounding a deployment, for example, and the clarity of the orders and its its purpose, etc.
Well, to some extent, this is relatively untested water. But one of the issues that we were looking at in the Rwandan War Crimes Tribunal was to broaden the concept of command responsibility, which up until that time would only related to military commanders, to broaden that concept to include civilians. And indeed, that's what's happened. The situation in Rwanda was such that those who held power as civilians held a very significant amount of power. It was almost like a military operation. And they could command and control civilians who were within their organisations. And the team that I led in the Rwanda War Crimes Tribunal was looking at the use of the media, in facilitating, in sensitising the Rwandan population to commit or to assist in committing the genocide. And the last time that had been considered was in Nuremberg, just following World War II. The directors of what was known as Radio RTLM had enormous authority, and ultimately the command responsibility requirements have been broadened and now include people in that sort of an environment. So if civilians are performing a military commander type role, then they could be subject to criminal prosecution.
Oh. Okay, so Craig, thinking about, I mentioned a couple of cases earlier, and as we talked about the break and rank trials and so forth, in relation to the war crimes allegations that have been aired by the ABC and what's known as the Afghan files, are there any other historical precedents in Australian military experience that are relevant to potentially to those cases that might be coming forward?
Not to my knowledge. The most recent matter that has some parallel was the prosecution of, I think it was 3 British soldiers, one of them being Corporal Payne in 2006. Proceedings were brought against him pursuant to essentially the UK equivalent or the English equivalent of the provisions within the Commonwealth Criminal Code. And he was convicted of a war crime. That is the most recent example that I'm aware of. And I'm not aware of any specific examples involving ADF personnel.
Has there been many examples internationally of war crime prosecutions from, I guess, from the coalition of the willings of America, Canada, European countries, etc.?
Look, Mark, it has happened. Just a very broad compass. If I can just answer the question this way, because there was the My Lai massacre perpetrated by United States forces in Vietnam. There have been examples through history of individual criminal responsibility for actions on the battlefield. And this is nothing new. This development of what's referred to either as the law of war, the law of armed conflict, or international humanitarian law, it all means the same thing. And the more recent development specifically of international criminal law, which flows from that, has been developing for hundreds of years. And the Geneva Convention and the two protocols, the Geneva Conventions, came about in the mid 19th century. The protocols more recently in 1977. But there has been a steady advancement of holding individuals to their responsibility to conduct war or armed conflict in accordance with some fundamental principles.
Craig, one of the things that I need to ask you about is about the difference between these sorts of prosecutions and, say, a civilian prosecution. Can you tell us a little bit more about that?
Yes, Mark. In many respects, they're fundamentally different from the investigation phase right through to the end of the prosecution phase. The significant difference between the two is that in a domestic criminal environment, say, for instance, take the offence of murder, you have the person who has been killed, and that's an unlawful killing. It will always be an unlawful killing within a domestic arrangement unless you're acting in self-defence, as opposed to a murder occurring during a military operation. Now, allegations that I've read about in the media point to potentially unlawful killing having taken place, at least that being the allegation. It's not simply a matter of there's a dead body and therefore that person has been killed unlawfully. Remembering that soldiers on behalf of the government act as their agent, and in armed conflict, whether it be international armed conflict or non-international armed conflict, their rules of engagement can and do include the use of force up to including lethal use of force. And that force can be applied without any immediate threat having occurred. And indeed, on many occasions, you'd want to take the first shot, as it were, so that you're not putting yourself at risk. So effectively, you, if you're operating under that environment, have been given a license or authority on behalf of the government to kill in those circumstances. It's just brutal, but that's what it is. So the first thing that has to be done in a war crimes prosecution is to prove that there is a conflict, and then prove whether it's a international armed conflict or a non-international armed conflict. Different rules apply to those. And also there are different offence provisions within the Commonwealth Criminal Code that apply to an international armed conflict as opposed to a non-international conflict. Then you move to, all right, so what authority has been given to take life? So that takes you to the rules of engagement, which may lead you to the particular orders for opening fire for a particular mission. So there's a whole, it's like an onion, really. There's a whole lot of layers that have got to be traversed through and proven by the prosecution before you actually get to the circumstances of the killing itself, and a determination as to whether or not that killing was authorised under the prevailing rules, the authorisation that the soldiers had, or had happened in circumstances where the death was unfortunately incidental to the carrying out of the military mission, which unfortunately happens often and can't be helped. And again, whether circumstances were such that the individual was acting in self-defence. So a whole range of issues that some of which apply in a domestic criminal prosecution, but very many of them don't. It's a highly specialised environment, and it is a prosecution that involves many steps.
So, Craig, what do you think, or not what you think, what do you know of Australia's obligations to investigate and to pursue war crimes allegations? Do we have certain obligations that we must adhere to and that kind of thing, or is it up
Yes.
to us to decide how we want to approach those issues as they arise?
Well, certainly there's always been an obligation on states to because of the universal jurisdiction that encapsulates war crimes to investigate on your soil crimes which may have been committed in a conflict that took place far distant from the shores of Australia. But specifically in regards to Australia's involvement with whether it be peacekeeping missions or warfighting missions or any type of mission which may lead to the application of force, there is an obligation pursuant to the Rome Statute, which, as I said, Australia is a signatory to actually investigate and prosecute as required. If we don't, then the International Criminal Court, the prosecutor of the International Criminal Court, can reach in and take over an investigation and prosecution. So potentially, if Australian authorities didn't investigate and consider prosecution flowing from allegations which have been made in relation to any of our military operations, but in this case it's Afghanistan, then there's a real risk that Australians could find themselves in The Hague, essentially before a foreign court, answering allegations for their actions as soldiers during the Afghan conflict or elsewhere.
Right.
So there is a positive obligation to do that.
Yeah, okay. So what are the judicial procedures that would be followed should any allegations come forward and something be preferred for prosecution? What happens next?
Well, as I said, the war crimes offences are contained within the Commonwealth Criminal Code, and potentially there are two avenues. The first, and I'm not putting this in any particular order, but one avenue is, using a military jurisdiction via the Defence Force Discipline Act, and under one of the sections, Section 61, the Commonwealth Criminal Code is effectively absorbed into the Defence Force Discipline Act, and as long as there is jurisdiction to actually charge someone under that act via the offence provisions of the Commonwealth Criminal Code, Division 268, then potentially there is that avenue. The other avenue is via civilian courts in circumstances where a military court doesn't have jurisdiction. But either way, before any prosecution is commenced, the Commonwealth Attorney General must consent to the prosecution.
Okay, Craig, that lays it out, and it seems that there's a few things that need to be sort of ironed out as part of the proceedings. I'm interested to understand your thoughts on, and I guess this would be a good point for us to close out on. Do you have any thoughts on how these allegations and potential prosecution could change the way in which ADF conducts its operations in the future?
Yes, sorry, Mark, you were breaking up a little bit there, but I think I understand.
Do you want me to repeat it again, just in case? Because if it doesn't come clear through to you, then it might not come clear on the recording as well.
Okay.
So, Craig, the question I was asking is, do you have any thoughts on how these allegations and potential prosecutions could change the way in which the ADF conducts its operations in the future?
Look, within the Defence Forces, I'm sure you're well aware, Mark, law of armed conflict training is something which is fundamental. And with all of our training regimes, it's reinforced throughout the soldier's career. Prior going on an operation, there is training which deals specifically with law of armed conflict scenarios. And I would think that ADF personnel are well versed in the fundamental principles underpinning the law of war, underpinning the Geneva Convention and the additional protocols. But looking at it more broadly, there is no doubt that those with the responsibility will be looking very carefully at both the command and control aspects, of cultural aspects associated with any potential wrongdoing that's established through any criminal court process. From my perspective, it is essential that that those who are responsible, whether it be politicians or senior military commanders, give clear and unambiguous direction in respect of the left and right of arc of the conflict or the operation that they're expecting Australian servicemen and women to enter into, and targeted training towards that direction. Now, the direction comes in a hierarchy of documents, whether it's the national policy at the top of it, orders for opening fire at the soldier's end, and rules of engagement somewhere in between. But at every level, all of that material has to work seamlessly, so there can be no confusion on the ground, and we're able to train to it. And then lastly, there needs to be effective oversight, because our servicemen and women are operating under incredible pressure and have had to, due to resources, undertake return missions frequently, which again just adds to that pressure. So they need not only direct support in the manner in which they undertake an operation, but there needs to be effective oversight so that they're being managed in a way that protects them.
Yeah, so I would put it to, if you ask a defence ADF person if they want to go on operations, they would say, yes, I want to go. And in some cases we've seen people, it's been reported of 8 or 9 tours. That's a lot of mission time. These tours they're not short periods of time. There's a big build up, and they spend a lot of their time in these conflicts, and there's a very high pressure environment. And of course, this whole thing needs governance and oversight. I absolutely agree with you on that. Craig McConaghy, thank you so much for enlightening us about the rules of law, and I appreciate